The main European standards concerning data protection and the right to privacy are composed of both European Union and Council of Europe legal instruments. And it's very important to closely follow both legal frameworks, and they have been both presented in our course. The main important instruments are obviously European Convention of Human Rights and EU Charter of Fundamental Rights. They contain general provisions under which the right to privacy and the right to data protection are protected, although it has to be noted that as regards the European Convention of Human Rights, both data protection and right to privacy is protected under Article 8, whereas with regard to the EU Charter of Fundamental Rights, the data protection and the right to privacy are protected as separate rights. So in case of the Charter, the right to data protection has been established as a separate fundamental right. Apart from Convention and the Charter, there are also other legally binding instruments. For example, the Data Protection Directive at the EU level, or the so-called Convention 108 developed by the Council of Europe. What is also important is the jurisprudence of the European courts, such as the European Court of Human Rights or the Court of Justice of the European Union. They both provide very important case law that has been growing very rapidly recently, and probably this process will continue. And they are important because they are a very significant instrument of interpretation of the Convention or of the Charter, which are living instruments, and through the case law of the European courts, they can be adjusted to the changing environment. Finally, there is also soft law, which is basically non-binding standards that are produced by different institutions, bodies, sometimes bodies that are specialized in data protection field. That is, for example, Article 29 Working Party that works within the European Union. And even though, as I said, these standards are not binding, often they are very specific, they tackle very concrete issues, and therefore I believe may be also very helpful for the national legal professionals. Standards related to the right to privacy and the right to data protection are crucial for the legal practitioners at the domestic level, because I believe that the challenges related to those areas are getting more and more common, are getting more and more sophisticated, and the legal practitioners are being confronted with these challenges more and more often. Also, it's important to note that they are very much linked to the development of new technologies that, well, usually are faster than legislations. That is why national laws do not offer a ready-made answer for all these challenges. By following the European standards on data protection and right to privacy, as a national lawyer, first of all, you contribute to a better, more full effectiveness of, for example, European Convention of Human Rights or EU Charter for Fundamental Rights at the domestic level. And secondly, you can find there very useful guidelines that may simply help you to resolve your own national cases.